Hello, my name is Julia Marboe, and I'm an associate on the employment practice group at Theiss in Vienna. And I'm happy to talk to you today about the five do's and don'ts when restructuring. Before, I would like to introduce our law firm a little. Theiss is one of the leading law firms in Central, Eastern, and Southeastern Europe. We have built a reputation on a combination of unrivaled local knowledge and strong international capability. We opened our first office in Vienna 60 years ago. Our team now brings together over 340 lawyers from a diverse range of backgrounds, working offices in 13 countries throughout the CEE and SEE region. Through our international network of offices, we work closely with our clients to help them solve problems and create opportunities. Your employees are your company's greatest asset. Having the right structures in place to protect these key relationships can prevent problems before they arise and secure the long term future of your business. Our regional employment team, with an average of 10 years of experience in the field, can help you to manage your risk associated with human resources. Employment law changes quickly, and countries respond in different ways. We can assess what is most valuable to you, and you can count on us for straightforward advice rather than having to wade through pages of arguments pro and con. If you have an international business or one with international ambitions, our 13 full service offices have the flexible approach you need. We can advise you on international employment projects with the collaboration, when necessary, of our experts in corporate, dispute resolution, regulatory, and tax law. We are equipped to help you navigate the whole gamut of employment law, whatever the issues you're confronted with, from day to day employment management to litigation, from remuneration to restructuring. You can rely on our services, which are customized to best help you meet your long term business goals. Not only can we do all this, we can do it wherever you need, cross border, and on time. Now I'd like to share five do's and don'ts about restructuring with you. 1. Do analyze the current situation of your business and the intended restructuring measures in detail before going forward. For example, expected savings effect in comparison to restructuring costs, legal framework, time schedule, etc. Define goals and budgets. Form a task force and define the roles in the negotiation process. Try to accommodate Works Council and its members early in the process to make the whole negotiation a smooth experience. 2. Do define and use objective and measurable, as well as legally sound selection criteria when restructuring the workforce. 3. Do inform and consult with the Works Council upfront before the intended restructuring and a potential mass dismissal. 4. Do proactively start social plan negotiations with the Works Council in case the restructuring has a negative effect for a significant part of the workforce. 5. Do inform the Austrian Labour Market Service at least 30 days in advance of any planned mass dismissal, and additionally inform the Works Council at least 7 days in advance before the notices to the individual employees are issued. 5 things not to do when restructuring. 1. Do not start the restructuring process too late, as such a process usually takes some time. 2. Do not forget about restructuring costs when planning a restructuring. For example, social plan costs, entitlements under the old severance scheme, potential costs for court proceedings, etc. And think about the individual risk of challenging the termination in court for each concerned employee. 3. Do not ignore concerns by the Works Council, but rather address them and react with a strategic communication plan. Always remember, right information to the right person at the right time. 4. Do not go into the social plan negotiations without a strategy, a concrete draft of your first social plan proposal, a clear picture of the linked costs, and expect the possibility of a conciliation committee proceeding. 5. Do not violate the mentioned time periods for informing the Austrian Labour Market Service as well as the Works Council, as this could lead to the invalidity of the terminations. Thank you very much for listening.
5 do's and don'ts when conducting an employment restructuring exercise in Bulgaria. Number 1. Start with an assessment of the organizational structure of the company. Check if the different teams, units, and projects are properly designed and separated as per organizational charts, employment contracts, and so on. Be sure to identify if employees affected by the reorganization can be legally separated from the non-affected employees, or if they form one unified pool. Number 2. Prepare a step plan for the reorganization based on the chosen legal ground for termination, relocation, or reformation of the employees, depending on the case. Consider if any prior preparation may need to take place before starting the restructuring. For example, organizational changes or updates to clearly indicate the different work streams, units, and projects, or unit allocation of the employees to separate the affected and non-affected employees. Number 3. Check if mass dismissal rules may apply to the restructuring. Bulgarian labor law defines rather low thresholds for mass dismissals. For example, in a total headcount of 300 employees, the dismissal of 30 would trigger mass dismissal procedure. Mass dismissals require prior information and consultation with the trade unions, if any, and/or the employees' representatives, and are subject to procedures with the Bulgarian Employment Agency. Number 4. Make sure to involve the trade unions, if any, and/or the employees' representatives in the restructuring process and set the grounds for a constructive dialogue on the intended changes. Additional information and consultation procedures, apart from mass dismissals, may need to be complied with. And number 5. Assess if a selection procedure would be required to score employees subject to dismissal. Be careful when determining the selection pool and the selection criteria. Set relevant, verifiable, and non-discriminatory criteria, otherwise the score and related terminations may be invalidated in court. 5 things not to do when restructuring. Number 1. Do not start the restructuring process without a detailed step plan and a clear strategy. Carefully set each step of the process and consider any related formal procedures and timing that may be required. Number 2. Once started, do not change the restructuring process midway and stick to the step plan. Any changes in the course of the restructuring, whether that be the termination grounds, the scope of employees, or the selection criteria, may give rise to claims for abuse of rights, unfair terminations, and/or discriminatory treatment. Number 3. Do not rush and omit to keep complete records and evidences of the restructuring process and any entailed procedures. Should a subsequent court case arise, the company must be able to defend each step it has taken in the reorganization. Number 4. Do not hold meetings with employees without a detailed script and complete set of documents readily available to be executed on spot at the meeting. And number 5. Do not hold one-on-one meetings with the employees, as this may expose the company to untrue allegations and potential court disputes. Always have at least witnesses present at the meetings and be sure to keep proper minutes of each meeting.
Hello, my name is Dora Gaži Kovačević. I'm a partner at Theiss and I am heading our employment practice in Zagreb. What we will discuss today are the top 5 do's and don'ts when it comes to conducting a workforce restructuring exercise in Croatia. So let's start with do's. We have 5. First, set the restructuring plan, team and the budget. Second, define the selection pool and the selection criteria. Third, involve the employee representatives. Fourth, comply with collective redundancy requirements if applicable. And finally, consider possibility to enter into the mutual termination agreement. So now let's look closely to each one of them. First, set the restructuring plan, team and the budget. At the outset of any restructuring exercise, it is important to collect all the data and to put together a restructuring plan that will determine the scope of the restructuring process. The restructuring plan should primarily include an analysis of the grounds for restructuring, indications of the work positions that will be affected by the restructuring, and information on the employees being considered for dismissal. It is also important to gather relevant information regarding the involved costs in order to put together a realistic restructuring budget. Employers should be aware of the so-called golden rule. The higher the budget, the lower the risk of employment tribunal claims. The company should also gather the team of reliable and efficient local and global experts who will provide HR, legal, and tax advice during the project. Moving on to point 2. Define the selection pool and the selection criteria. In order to lawfully dismiss an employee in the restructuring scenario, the employer must be able to show the existence of legal reasons for dismissal. Restructuring due to business or organizational reasons is one of the legitimate reasons for dismissal. After identifying the work positions that are no longer required, the employer needs to identify the group of employees, the so-called selection pool, who will be affected by the restructuring based on justifiable business-related reasons. After determining the selection pool, the employer will need to evidence that each dismissal was based on objective considerations by fairly applying specific criteria to all employees within the selection pool. Certain social criteria are set out by law which the employer must apply if it employs more than 20 employees. These are the duration of the employment contract, the employee's age, and family support obligations. In addition, the employer has a discretionary right to apply additional selection criteria, such as performance, experience, skills, quality of work, responsiveness, and punctuality. Although the employer has an autonomous right to determine which of the above criteria it will give priority, its final decision should be based on objective criteria, and it should not be influenced by its personal opinion. To the extent possible, the employer should be capable of backing up its decision with evidence, for example, personal records. 3. Involve the employee representatives. Before implementation of the restructuring exercise, the employer should determine if employee representatives, that is, workers' council or trade union representatives, have been nominated within the company. If so, the employer should always consult with the employee representatives prior to any dismissal, and also obtain prior approval in case of dismissal of certain categories of employees. Moving on to point 4. Comply with collective redundancy requirements if applicable. The collective dismissal procedure is triggered if the employer intends to terminate the employment contracts of more than 20 employees in a period of 90 days, and at least 5 of such employees are terminated due to business reasons. In such a scenario, apart from the general obligation to consult the employee representatives or obtain the prior approval, the employer needs to inform the Croatian authorities of the restructuring process. The final recommendation is to consider possibility to enter into the mutual termination agreement. Entry into the mutual termination agreement represents the safest route for the employer as it protects the employer from possible employees' claims, and it should therefore be considered in any restructuring exercise. However, there are some important recommendations on what not to do during the restructuring, so let's continue with these. First, no hiring at the redundant positions should take place just before restructuring. It is very difficult to justify termination of certain employees while onboarding the newcomers. It should therefore be made clear to everyone in the organization that no hiring should take place on the same or similar positions that will soon be cancelled. Employers should also especially be aware of the statutory prohibition against new employment for the same working position within 6 months following a termination of the employee holding that position due to business reasons. What we often see in practice is that restructuring is planned and implemented at the group level. So the next few don'ts are related to properly conducting such process. Local communication and representation rules should be respected. Even if the decision on restructuring and dismissal of certain employees is made at the group level, local management board is the one authorized to make local decisions, sign documents, and if necessary issue powers of attorney. Therefore, it is important to inform the local decision makers about the process far in advance. Another don't relates to GDPR. There should not be any breach of GDPR rules in the restructuring exercise. In cross-border restructurings and central management of the process, we often see that rules on collection, processing, and transfer of personal data are neglected or even completely forgotten. That should obviously not be the case, and the employer should ensure that all procedures are in place. Complete information about the employees should be gathered. It is especially important to gather all necessary information in order to assess if there are categories of protected employees, such as particularly disabled persons or pregnant women. Such employees enjoy special protection. If the restructuring is handled at the group level, such information is sometimes not available. The companies should therefore regularly update all employees' personal files. And finally, the last tip. Tax implications of entering into the employment agreement should not be neglected. As already mentioned, although entering into mutual termination agreements is the most flexible option, there are also certain drawbacks. Employers' tax benefits and employees' unemployment benefits are lost, which makes the mutual termination more expensive and less attractive to both parties. And that brings us to the end. We hope that these tips were useful. Thank you for listening.
Hello to everyone, I'm Sabina Krajickova from Theiss, Czech Republic, and I specialize mainly in labor law. I would like to shortly sum up some recommendations with respect to restructuring from Czech law perspective. I will start with 5 main things which should be borne in mind during any restructuring proceedings. First of all, do always analyze the current situation of your business and the intended restructuring measures in detail before going forward. That means expected savings versus restructuring costs, legal framework, time schedule, and so on. Define also goals and budgets and roles in the negotiation process. Furthermore, try to accommodate employees' representatives, if any, early in the process to make the whole negotiation as smooth as possible. Afterwards, it is also important to define any selection criteria which will apply for employees' dismissal. In this respect, please also note that the selection criteria belong among the information which must be provided to the Czech Labour Office Authority in the event of the collective dismissal. Do always inform and consult employees in advance about the intended restructuring and potential redundancies. Where trade unions or work councils have been established at the company, this obligation can also be met towards these employees' representatives. More consultation obligations may even arise if the collective dismissal is triggered. In such a case, you are required to inform employees' representatives in writing, or if there are no employees' representatives, the employees themselves, about the reasons for the collective dismissal at least 30 days before serving any termination notices. And further, you must submit a written report to the relevant Labour Office Authority outlining the reasons and the outcomes of the negotiation with employees or their representatives. Always also try with the affected employees to terminate their employment by a mutual agreement to avoid potential unlawful dismissal disputes and prevent collective dismissal from being triggered, which may significantly delay the whole process. Now we can skip to some recommendations what definitely not to do during any restructuring process. As the timing is one of the crucial factors during any organization changes, do not start the restructuring process late in order to finish it not only by the intended deadline, but also taking into account any notice periods and consultation processes. As mentioned at the beginning, do also not forget to properly calculate restructuring costs, which may occur, in particular statutory severance pay, notice period compensations, but also consider potential costs for court proceedings if some of the affected employee decides to challenge the termination in court. During the consultation process, you should not ignore the concerns and proposals of the employees or employees' representatives were established. Before starting any negotiation with employees concerned, you should first internally discuss and approve termination packages in order to know the maximum proposal limits which can be offered to the employee. And finally, you should definitely avoid violation of the duty to inform and the obligation to consult employees' representatives to prevent any sanction from the labor inspection authority, which can significantly increase the entire restructuring costs. In this respect, do also not forget to inform and cooperate with the relevant labor office authority within the statutory deadlines. Well, that would be probably all from my side, and I do really hope that you find our summary useful and helpful. Thank you for the attention.
Hello everyone, this is the Theiss Bucharest office employment team. My name is Adelina Iftime-Blagean and I'm a counsel with the local employment practice of Theiss in Bucharest.
And I am Andreea, a senior associate within the same team.
This presentation is about few tips and tricks regarding restructurings in Romania, which in principle apply to both individual and collective redundancies. While in Romania redundancies are not necessarily costly and employees do not need to agree on a social plan nor have a right to veto the process, the core focus is on procedure and justification. I will start with a roadmap of the top 5 to-dos for a successfully conducted restructuring process. First, prepare a clear justification of the restructuring, which should include the current organizational chart and the proposed organizational chart, why exactly the positions envisaged to fall in scope of the redundancy process are not needed anymore, and what are the envisaged positive outcomes of the restructuring. If the aim is to avoid collective redundancies, special attention should be given to the justification of the subsequent restructurings, which should not be based on the same underlying reasoning, as well as to the overall number of affected positions and people. Second, pay special attention to the selection of the employees occupying identical or similar positions. Make sure the criteria are clear and well communicated, and that the actual implementation is well prepared, transparent, objective, and not discriminatory. Do not forget that until you make the selection, restructurings concern positions and not people. Third, while the strategy, coordination of the process, and drafting of the core documents and templates of individual documents can be done at a centralized level, the actual implementation requires a core in-house coordinator and implementer at local level, meaning within the Romanian entity implementing the restructuring. Identify such individual or individuals and offer appropriate retention agreements to properly incentivize them. Fourth, if there are no trade unions or representatives of the employees appointed, any information and consultations process needs to involve the entire headcount. Consider potential logistical issues and allocate sufficient time in the timeline for this process. Fifth, rather frequently restructurings also involve changes or recalibrations of positions, including demotions. Please consider that demotions impacting on the contractual terms and conditions require the employee consent. Assess whether the employees targeted for demotions should be included in the dismissal process, meaning the current position being eliminated and the new or demoted one being created and offered to the employees in scope, since this may impact the qualification of a dismissal process as a collective redundancy.
I'm going to move forward with a segment on what to avoid when performing redundancies. First, do not omit to perfectly follow the procedure, especially in collective dismissals, and give special focus to the communication with the employment authorities. Each chapter of a collective dismissal process involves certain mandatory interactions with the employment authorities, and therefore we advise you to monitor any delays in the timeline generated by the business needs, since this must interact properly with the legal timeline. Moving on, do not show all your cards from the beginning. While the legal protection of the dismissed employees is low in terms of severance and prior notice, with there being no mandatory severance payment in Romania and with the prior notice rather low of only 20 business days, offering some additional benefits following the consultations process will be perceived as a sign of good faith and will thereafter streamline communications with the employees. This approach will also be endorsed by an employment judge should the dismissal reach a more contentious stage. Hence, do not offer all that you intend to offer from the beginning, but rather as a result of the consultations process. Also, think about offering extra packages to reach consensual termination rather than conduct dismissals. Do not forget about the employees protected from dismissal and design a plan on how to deal with these employees. Pay special attention to suspended contracts, especially those for maternity or child care leave, and take these and the vacant positions into account when planning the redundancy. Do not forget that unexpected situations always arise. For example, the need to change the dismissal plan due to customer or business needs. Be vigilant and treat every particular situation with special care. Do not forget to involve other specialists early in the process. For example, a PR specialist would help avoid potential leakage of information to the press earlier than intended, while a change management specialist would help deal with remaining employees when the redundancy does not affect the entire headcount. All in all, we advise you to treat any redundancy cautiously, since a poorly handled dismissal can lead to reinstatement of employees and the award of damages, which in principle are equal to the value of the index salaries up to the actual reinstatement date, and potential moral damages, the amount of which is generally not very significant. Okay, so that's it for this presentation. Thank you for listening.
We hope it was both useful and enjoyable.
Hello everyone, my name is Jozef Virčík and I am from Wolftaj, Slovakia, and in my practice I specialize mainly in labor law. Today I would like to discuss some recommendations when it comes to restructuring, focusing mainly on the things you should do and the things you should rather avoid doing when it comes to restructuring under Slovak law. As regards the things you should do in case of restructuring, you should always set goals of the planned restructuring and analyze whether intended measures will bring the desired results in an effective way, taking into consideration the downsides of the restructuring from both short-term as well as long-term point of view. Do always consider other alternatives of achieving the desired goals. If, after detailed analysis, restructuring is the preferred way how to achieve the set goals, you should define the scale of the intended restructuring and the number of the affected employees. When defining the scale, do analyze the overall number of employees and whether the intended redundancies will qualify as collective redundancies, which may significantly prolong the whole process. Do assess the presence of the employees' representatives in the company and the agreed internal rules defining the information and consultation obligation. You should also define priorities. In a restructuring process, it means you should decide whether you prefer to allocate more money for employees in order to smooth the restructuring process by offering generous severance packages, or you want to limit restructuring costs to statutory minimum, what may lead to more lengthy process due to lack of cooperation by employees, as well as increase the risk of potential lawsuits. You should also prepare a timeline for redundancies, taking into account the information and consultation obligations towards employees' representatives or employees themselves. In case of collective redundancies, initiate negotiation regarding measures enabling avoidance of collecting redundancies with the employees' representatives at least 1 month prior to commencement of the collective redundancies. Provide the employees' representatives and the labor office with the mandatory information in written, and once the negotiation takes place, provide labor office with the information on the outcome of these negotiations. As the last recommended thing to do when restructuring, you should always prefer termination of employment by agreement instead of giving a notice in order to minimize the risk of potential unlawful dismissal disputes. As regards the things you should rather avoid doing when restructuring, we believe that first of all, you should not have unreasonable expectations when it comes to duration and timing of the restructuring process, considering mainly the scale of the restructuring in terms of affected headcount and other relevant factors such as presence of any employees' representatives or qualification of redundancies as collective ones. In terms of timing, you should take into account the unexpected delays which may occur between restructuring steps. You should also avoid having unrealistic expectations with respect to restructuring costs. This means that you should make budget calculations upfront and take into consideration statutory severance payments, notice periods, and also allocate money for additional severance payments in order to motivate employees to agree with termination by agreement to speed up the whole process. You should not ignore the concerns and proposals of the employees' representatives or employees themselves, as they may contribute to a discussion and offer interesting ideas and solutions to the problems, while at the same time you express concern with respect to employees, what may certainly reduce the tension between the parties and the risk of potential lawsuits out of employees' anger. Do not also forget about the restriction to terminate the employment relationship in case the employees are in the protective period, for example, in case of maternity leave, or if they are protected against termination if the state subsidies were drawn with respect to COVID-19 situation. Last but not least, you should not underestimate importance of a good planning of the restructuring upfront, and you should not forget to identify all the obligations towards employees, employees' representatives, and the labor office. Please always consult with experts, as the proper planning and implementation of restructuring can save employers considerable amount of money in the future and protect them from potential lengthy judicial proceedings.
Hi, I'm Olena Kravtsova, an associate at Theiss, Kyiv, Ukraine. I will summarize the top 5 things the employer must do during restructuring, particularly during redundancy, and the 5 things the employer should not do. So, the 5 things to do when restructuring are: Number 1. The redundancy process should be duly planned and organized in advance. It is recommended to define the purpose and legally sound selection criteria for redundancy, and to determine a particular reason for redundancy, the quantity and categories of employees planned to be dismissed, and the timing of dismissals. This information should be included in the company's internal order on planned redundancy that should be issued 3 months before such planned dismissals. Please note that the prevailing right to keep the job in the case of redundancy is given to employees with higher qualifications and production level. If several employees have the same qualifications and production level, the preference is given to the employee who has the preemptive right to keep the position, such as married employees who have at least 2 dependent individuals, employees whose family members are unemployed, employees studying at a higher educational institution, employees with a lasting, uninterrupted work experience at a given company, war veterans, including people with disabilities, and persons rehabilitated by law from among those repressed, authors of inventions of useful models, industrial samples, and innovation proposals, and others. It should be also considered that certain categories of employees are generally protected against redundancy. Number 2. Inform and consult with the trade union or union representative, if established upfront, about the intended restructuring or redundancy. According to law, at least 3 months prior to the planned dismissals, the company should provide information about such dismissals to the trade union, including information about reasons for dismissals, the quantity and categories of employees that are planned to be dismissed, the timing of dismissals, as well as consult with the trade union regarding the measures aiming to prevent or minimize the employees' dismissals. After the employees subject to redundancy are selected, the employer should receive the approval of the trade union or union representative in respect of the dismissal of a particular employee if the employee is a member of the trade union. Number 3. Inform the local employment center on pending organizational changes in case of massive redundancy. The employment center should be notified 2 months before the planned dismissals. Redundancy is considered to be massive if, at one time or during 1 month, 10 or more employees in the company having from 20 to 100 employees are dismissed, or if 10% or more employees in the company having from 101 to 300 employees are dismissed, or 20% or more employees are dismissed during 3 months, notwithstanding the total amount of employees in the company. Number 4. The employer should inform each selected employee personally and in writing of his or her planned dismissal. The notification is served individually to each employee with receipt confirmation 2 months in advance of such planned dismissal. We recommend to keep and store the documents confirming the receipt of such written notifications. And number 5. The employer should offer an employee who should be dismissed any vacant position that may appear in the company during the 2 months notification period after the employee is notified of the planned redundancy. Only in case the employee rejects to accept the jobs offered, he or she can be dismissed. And now let's talk about the 5 things not to do when restructuring. Number 1. Do not lay off the so-called protected categories of employees. For example, pregnant women, women having children under 3 years old, single mothers having children under 14 years old, or children with disabilities, etc. Number 2. Do not lay off employees while they are on sick leave or vacation. Number 3. Do not forget that employees dismissed under the redundancy procedure have a preemptive right to be re-employed by the company in case a vacancy for a similar position or qualification is opened by the company within 1 year after the redundancy. So, in case the company is going to hire employees of a similar position or qualification within 1 year after the redundancy, the company should offer the relevant job to the dismissed employees. Number 4. Do not forget about restructuring costs when planning a restructuring, including severance, and think about an individual risk of challenging the termination in court for each concerned employee. As noted before, the employees should be notified at least 2 months in advance and paid severance in the amount of at least 1 average salary. Internal documents, for example, internal policies, if any, and employment agreements may provide for additional benefits for employees in the case of redundancy. Therefore, they should be checked in advance. So, in order to terminate the employees by way of redundancy, the employer should reserve cash amounting to at least 3 employees' salaries. And number 5, the last but not least, do not violate the procedure and the terms provided by Ukrainian law for the redundancy procedure, as this could lead to the invalidity of terminations and to the reinstatement of the dismissed employees. In the case of reinstatement of an employee, the employer is obliged to pay such employee's salary for a period of forced unemployment as well as moral damages.